All right, everybody. Welcome to the Creative Finance Collective. We appreciate having you. If you're just now joining us, we're here to talk about all things creative finance and answer any questions that you may have along the way. So if you've got a question, make sure to post it in the chat. There are no stupid questions, so make sure to bring them. We're happy to address them. I'm Andy Fowler. I'm also here with Sean St. Clair. We may get a couple other folks that come and have a question, or other attendees to the Creative Finance Collective. If they come along, we'll introduce them as well. Make sure, just a couple housekeeping items. You'll notice at the top of the screen, at the corner, there's a barcode. If you're watching from another location that is not YouTube, that barcode takes you to YouTube, which is really kind of the best platform to interact with the collective and ask questions, so on and so forth. So go ahead and scan that, go there, subscribe, we'd appreciate it. Helps us out a lot. All right, so we're going to get into it. So another couple rules to the game here. We'll be on for as long as an hour to answer questions or until we stop getting questions. So it's important for you all to bring whatever questions that you have. We do have a couple questions in the YouTube channel, so I'm gonna go ahead and read those off. Sean, they're not on the screen that we can see, and they're on YouTube, so I'm gonna read this off for you. But it says, if I'm a subject to seller, how does getting a note and a deed of trust, in parentheses, mirror app, help me, and what can I actually do in reality if the buyer stops paying? You're
Yeah.
muted.
So
Go ahead.
am I
I
muted?
unmuted you. You're fine.
Oh, okay. You're quick. So basically, you're making the seller a lender. And what the performance note and deed of trust is going to state is that the buyer will pay the mortgage or pay you an amount as agreed. And then you use those funds to pay the mortgage, or it's paid to a servicer and then it's paid. But there's a payment obligation in the promissory note, which is secured by a deed of trust against the property. The deed of trust is a lien against the property. And if you don't perform, then the seller has the ability to basically foreclose on the property and take you out. And upon foreclosure, they generally, because of the way the credit bid would work, they will come back onto title and they can then sell it to somebody else. They can, do with the property as they may. So it puts them almost in the same status as their lender. I mean, all the same the note and deed of trust is a very similar document to what they signed with their lender. It's going to have very similar terms. The other thing is, if you're a sophisticated seller and you understand what you're, doing, and if I represent the seller, I'm putting a due on sale clause in there, into the deed of trust, which is going to be a due on sale clause very similar to what the lender has. And then if the buyer goes and sells it out from under the seller, they have a right to declare the loan due and, have it paid in full. And so it basically puts them on a very similar level as their original lender with basically most of those rights. As an investor, you want to negotiate that the due on sale clause is not in the document, so you can, do your own wrap or agreement for sale or other disposition of the property. But it really depends on, the negotiation and the leverage, whether or not that term ends up in the documents.
We just had join us Scott Horne. Scott, how you doing? Can you hear us okay?
I can, unfortunately, in the car again today.
Well,
Down in beautiful Austin, heading home finally.
Yeah, well, that's okay with us. We're happy to have you any way that you can appear. Sean was just answering a question posted by a listener asking about why you need the note and deed of trust, and they have a follow-up question, or at least I should say, why does the seller need a note or a deed of trust on a wrap transaction, and how does that help them? They have a follow-up question, so I'm going to read that, let you guys address it. But it says, do I have to foreclose on the home that I have the original mortgage in my name? Would I end up with anything after the original mortgage is paid after auction?
Okay, I don't understand that question.
Yeah, repeat the question.
Yeah, so it's the same. That's the same person posting the question, following up to the initial question, which was, how does the note and deed of trust and a mirror wrap help me, and what can I do with it in reality? And then they ask, do I have to foreclose on the home that I have the original mortgage in my name? Would I end up with anything after the original mortgage is paid after auction?
Well, I'm just going to jump in real quick, let Sean kind of follow up as he needs. So, first off, I heard Sean's answer, which was completely accurate. But the reason when you do a wraparound mortgage, whether it's a mirror wrap or a traditional wrap or whatever it might be, without a mortgage that you carry back, a deed of trust is a security instrument. In the event of a default, you can't get the property back in your name, unless the property owner just elects to deed it back to you. So that to me is a fairly obvious answer that you have to understand. But if you have to foreclose on a wraparound mortgage, which obviously implies there is an existing debt, and it doesn't matter whose name the underlying debt is in, but when you foreclose on the wrap loan, you foreclose to any other liens that are on the property, meaning you take the property subject to that original first lien mortgage, whether it's yours or some other subject to type arrangement that you bought the home with. And so then you have the obligation to maintain those payments again moving forward. So you own the property subject to whatever that lien or liens may be.
Yeah, that's exactly right. So what that would mean, so to answer the second question, is you would bid the principal balance of your loan, which is the principal balance of the underlying mortgage. Well, no one's going to show up and pay that because they're still going to take it subject to the original mortgage. And so you're going to end up purchasing it, presumably, unless there's significant equity in the property. And if there is significant equity, that would be odd because you probably shouldn't have sold it for what you did. But nevertheless, once you foreclose, then you become, via your credit bid, you're going to end up, purchasing it and being the record title holder. So if there is equity beyond the first mortgage, at that point, you have the right to sell it and to reap that equity. So at the end of the day, the answer is yes. If there's equity in the property beyond the first mortgage and you're able to secure the purchase through your credit bid, which is likely, then as the seller, you will then own it and you could then go and sell it for whatever the fair market value will provide. And if that's more than what's owed on the first, you get to pocket the difference.
Yep. And Sean and Andy, I will say with this, here in Texas, with the escalation of values, if you did a wraparound mortgage maybe 3, 4, 5 years ago, and that's the mortgage you're foreclosing under, you could have substantial equity in the property based on the pay down of your mortgage and things of that nature along the way. I'm not 100% sure how it works in Arizona, but here in Texas, obviously if you can bid whatever price you want to bid, and if you have an existing mortgage, obviously you want to bid at the bare minimum the balance of that underlying debt on the property.
Right.
But anything that is received over and above what you are owed on the property here in Texas goes first and foremost to any other junior lien holders of record in order of priority. And if there are no other junior liens on the property, then any overage proceeds go to the prior borrower whom you foreclosed on. I think a lot of investors sometimes, when they're going through a foreclosure, they think that, for instance, if their borrower owes them $100,000, but they sell the property at the auction for 50, that they get to pocket that $50,000 difference, and they don't. All they get is to be made whole with their interest and other fees that are outstanding due and owing, legal fees and things of that nature along the way. But any difference, let's just assume 50,000, would go back to their borrower and not into the investor's pocket. And I think a lot of investors don't understand that out there if they're going through a foreclosure process.
Yeah, that's exactly right. So if you bid 50 or your credit bid or your payoff is 50 and somebody shows up and offers 100 for the property and they throw down 100 grand, you get your 50. So you get paid. But there's 50,000 there that goes either to junior lien holders or to the owner who was the owner of record at the time of the foreclosure.
Yep. Let me make one more comment too while we're talking about foreclosures. I think a lot of people don't understand how this works. If it's what we'll call here in Texas at least a non-judicial foreclosure where the attorney trustee is foreclosing on the property, the attorney is going to, in most all cases, disperse those funds to the appropriate parties. But if this was a judicial foreclosure where there may have been a court order to foreclose, maybe it was a property tax foreclosure, which also requires a judicial foreclosure, again, meaning a court order, the excess proceeds go to the court and is put into their registry. And any lien holders or the prior borrower, if they know the money is out there, they have to go get it. And if they don't go get it, it will eventually escheat to the state of Texas.
Right. And even in Arizona, we have the two systems of foreclosure, the trustee sale and the judicial foreclosure. But and you're right, Scott, most trustees do have the ability to distribute the funds as the statute allows. But there's some trustees out here that are very conservative. And what they do is they actually will go and start an action and deposit the funds with the court and give notice to the parties of that action. And then those parties have to show up and, seek the excess proceeds. So those are the two options that the trustees have here in Arizona. That one, they can use their judgment, but others who are concerned that, they could get dragged into something will go and deposit it with the court, which they're allowed to do, and then take their fees from the funds for depositing it with the court. And then the parties have to go into court and fight about it. And then at that point, the trustee's out. So there's a lot of trustees that are conservative that way and go ahead and do that.
All right. Good answer to a question. We also have Alan Sesker joining us. Alan, how you doing?
Doing well. I thought I would just kind of lurk and troll out here.
All right. Well, all are welcome. The lurkers and the trollers included.
I just finished up with a little Zoom, went late, but I wanted to jump on and say hey to everyone.
All right. Well, thanks for joining us. We have another question. So if you're just now joining us, we're taking creative finance questions, and we'll take them as long as we get them up to an hour. So if you got questions, it's important you post them, or we're just going to move on with our day. I like this one. I think it's a good one to think about. Can I buy a manufactured home subto? Pretty simple question, pretty simple answer, but I think there's a lot of issues that surround the manufactured home. But what do you guys say to that?
So depends on if the manufactured home is legally attached to the property and has become real property or not. If it's become real property, then yes, we close those. If it's still personal property, we don't assist with that. And so I don't know if you can or can't. It's just a whole different process when it's not real property.
Yeah. So guys, for Texas, it also, no, just to echo what Alan said, yes, if it's real property, it's business as usual and a subject to transaction. But if it's chattel, which is personal property, meaning it's just like a car or a boat, um, I don't know of the mechanism to buy subject to that. Most likely there's an installment sales agreement somewhere. And an installment sales agreement is kind of like a contract for deed in Texas and or a agreement for sale in Arizona. So could a seller do another installment sale agreement to a buyer under the exact same terms and conditions? Yes, they could do that. You could do that with or without liability as well, whatever the parties negotiated. But there's a different process to doing that along the way. And then there might be a bill of sale involved based upon the transaction. If you're actually going to transfer the full title of the manufactured home, you might want to file a UCC lien to do that. And it's just a different mechanism here in Texas. I have no idea about Arizona per se.
So, and what you were getting at with the installment sale is exactly what you have to consider in this type of transaction, because the manufactured home, at least here in Arizona, it sounds like in Texas, is going to be treated as far as title and registration the same as a vehicle. And so the significance of you, Scott, describing an installment sale is the fact that title is not held in the owner's name. Title is held by the lender. And so there's a certificate of title that will show whoever the owner is as the owner, but then it's going to list the lender as the lender or secured, lender on the title, and the lender holds the title. So it's not like you can walk into the MVD and say, oh, here's the title, I'm conveying the title to so-and-so, and there's still a loan against it. It doesn't work that way. The lender retains the title as security for their repayment, and the lender's not going to give you that title until that loan's paid off. And so from a logistical standpoint, you cannot register the manufactured home into a new buyer's name unless they're given the title. So to your point, you have to do something else that retains the title in the original seller's name. So that could be an installment contract. It could be a lease with an option to purchase, is another instrument that you can utilize to at least, acquire an interest in or a possessory interest plus the right to purchase in a manufactured home. But so the answer is it can be done, but logistically it's done different than a traditional subject to, where you can actually convey title via a warranty deed despite the loan remaining in place.
And guys, I'll let you know one thing too. It's kind of unique about the manufactured home versus real property. You can actually convey ownership of the manufactured house to a buyer, and you can put a lien against that property and record that lien with the Secretary of State's office. But if you do that, you are going to go through a judicial foreclosure. It's going to take you probably 6 months or so in order to get permission to, it's not really a foreclosure, but for ownership of that property, and then go through an eviction suit thereafter. Whereas with an installment sales agreement of some type, you can put your default provisions in that just like any other contract. It could be like, as you said, Sean, a lease with an option to buy, where maybe payments are due on the 1st, late on the 5th, or you can make them due on the 1st, late on the 10th, or require a 10-day notice to cure or a 30-day notice to cure. Whatever that might be, it's whatever the parties agree upon. And so just different rules and regulations. If you're going to play in that game, you better know what those are because they are very different than real property.
Yeah, that's exactly right. And unlike a vehicle, so a manufactured home is titled and registered in Arizona like a vehicle. It has a VIN. But unlike a vehicle, you don't, because it's a residential dwelling, you don't have the right to like just go and tow it out of the yard that it sits in or whatnot. If people are living in it, you would have to go and actually evict them. Versus a vehicle, you can repossess the vehicle non-judicially as long as you don't breach the peace and in the process or trespass in doing so.
And then I've seen situations where the mobile home lenders or sellers will do a qualified assumption and switch out, but sometimes it hurts to ask.
Funny. All right, we have another question. This isn't really a subto question, more of an owner finance question, which is kind of similar but different. Can I require prepayment penalties on an owner finance transaction?
Scott, you want to? I know you. Don't you have a loan origination firm as well?
We do.
Yeah.
And of course, all of this is always problematic. And I want to talk in a moment also about this 10% rule here in Texas, or something like this that's floating around right now. But if you are, the question really becomes first and foremost is the borrower, or is the seller, the investor, under Dodd-Frank?
Mm-hmm.
And to be under Dodd-Frank, we believe you have to do 5 or more transactions in a 12-month period. Most investors don't do that volume. But if you do, there are some prepayment penalty rules that you need to adhere to. They have to be reasonable. If you are in a high-priced mortgage realm, which I hope nobody ever is, then they are not allowed. But if it's a high-cost or a QM mortgage, you can. But again, they're going to limit you typically to about a 3% prepayment penalty over a reasonable time frame in that instance. The whole key is being reasonable. So you can put a prepayment penalty in there. Most people are technically not under Dodd-Frank, but we always suggest to do your best to follow that. It's just a smart rule of thumb. And don't try to mess people around at the end of the day. So The short answer is you can put it in there. Depends. Make sure you're under Dodd-Frank. Make sure you're following those rules. And if you have questions, ask that arm below in what's going on. But I think that's a federal issue in that regard. And there could be a state requirement as well.
Yeah.
And what I find interesting, guys, and Alan, you may be tracking this a bit too. A few months ago, this thing here in Texas rose up about a 10% interest rate on a wraparound loan. And if you read the Dodd-Frank Act, which is something you don't want to do, it makes great bedtime reading, really. But Dodd-Frank defines a wraparound mortgage, guys, as a subordinate mortgage, not as a second lien. Well, here in Texas, we just went through an audit with our RMLO company, and you learn a lot of things along the way. And along the way, one of them is that the state of Texas is classifying a wraparound mortgage as a second lien. And you're going, what? And again, I guess they can do that. And so I was referred to the Texas Finance Code. One section is 302, there is 342. When you read that, it does say, basically the definition is that a wraparound mortgage is a second lien. And what happens is there's some things that come into play, and I think the Savings Loan Administration is wrong, that if your interest rate is more than 10%, now there's all these rules and regulations you've got to follow under these statutes. You can't charge a servicing fee, you can't charge a prepayment penalty. There are certain fees you can and cannot charge, etc. And I currently have an email into them asking those questions specifically because I want a definition of this. Now, it does say in there for Texas, and again, for everybody listening, Texas is the most problematic state for this business out there that I know of. So this probably only applies to Texas and not to any other states. You need to make sure you talk to an Andy or a Sean or the similar person in the state wherever they're listening. But a seller who is selling a home can carry back a second lien on their property, and it's exempt from these statutes. I think it's exempt from one at least. But the state, for some reason, is raising this issue right now, and I'm not sure what's going on or why. But trying to get the bottom to that a little bit. Have you heard that out there, Alan?
So I heard some scuttlebutt. Someone came to me and said, "Hey, what's the deal? We can't charge transaction or loan servicing fees." And I looked into it. I think I'm 100% similarly situated as you. It is a second position. It's a second lien position, but it's not a second lien in the way that the code is contemplating. They're
exactly
contemplating
right.
a first lien and an additional second lien, and you put those two together, and that's the amount that's borrowed. So it's completely different. We may need to boost our lobbyist protection out here for RAPs to correct it. But I think by the letter of the law, they're correct, just not the intent.
No, and again, I know we're kind of talking Texas specific here for a moment, but I think they intend it to refer to a traditional second lien mortgage where there's a first lien lender and a independent second lien lender that is out there. But they're trying to, again, put a square peg in a round hole and classify the RAP mortgage as a second lien for that designation purpose. And I think they're absolutely doing it wrong. So I had received an outline from one of the guys at Savings and Loan Administration. They had written up for obviously a seminar or something they had put on. So I emailed that gentleman hoping to get an answer back. If I do, I'll let you know, Alan.
Yeah, do.
All right, good stuff. We have another question. How important is title insurance in a sub-2 transaction? I think as a general rule, real estate lawyers think title insurance is pretty important all the time, but is there a difference in a subject to transaction as to why you might be less concerned about title insurance?
So there is, selling your property, seller finance, whether it's seller finance wrap, seller finance assumption, or straight seller finance, no underlying. The title insurance policy is going to come in and state that the owner policy continues. And so if you're not concerned about title issues from when the seller purchased that property and now, you still have that coverage from prior to their purchase. But you're correct. Attorney's going to say always get title insurance. An investor is going to say do a risk analysis and figure out if title insurance is needed. If it's only been 3 months or so since a refi or purchase or acquisition, then maybe it's not as important. Get yourself a title search on every single transaction. Absolutely. But I will have to confess, I don't buy title insurance on my assumptions and subto acquisitions, but I also have a free title attorney who's going to help me if there's a problem. So
yeah, but he's not a very good one, is he?
No, he's not, but he's free.
Well, it's kind of like beer. The only kind of beer better than free beer is other people's beer. So I get that. I'm going to add on to that a little bit too, Alan. From a subject to perspective, in Texas, unlike Arizona, there's only 3 kind of liens that can attach to a homestead. And I'll tell you that 98% of the transactions that we close are homesteads. And those liens are a purchase money mortgage, a tax lien of some type, and or a properly executed mechanics lien contract. Everything else can be removed from a homestead property. So from a subject to perspective, knowing that the lender's mortgagee's policy is still in place, if you don't want to pay for one, like Alan said, I rarely buy one myself either. I don't think I've ever bought one, to be honest. But I also have one of those free title guys that does the research for me.
But they're getting old.
But
I had to jump in.
Yeah.
I had to at least ping pong that ball back over the net.
Yeah, and it crashed his internet.
It caused him to go on.
Yeah, that's he can't even handle it. We'll see if we get him back.
Looks like he's traveling still. Now, last week he was out there, right?
Yeah, last week he was traveling here in Scottsdale. Now I think he's running around from court to court. We'll see. All right, so we have another question. I think we addressed the title insurance issue pretty well. How do you handle liens filed in the gap between obtaining abstract of title and closing, or these liens that get missed, or couldn't have been seen but are figured out after closing? You ever run into that, Alan?
Oh yeah. I've had all kinds. We had a buyer come to us. A mechanics lien was filed one day before closing, and it was funny. The title insurance company took the side that well, you owe those funds. That contractor is due the money. And I said, no, we dispute the mechanics lien. The reason they're filing that is because there's a dispute. We do not owe that money. And so fought back and forth a little bit, and insurance came in and took care of it. Have a horror story going on right now where AJ was filed and immediately executed upon, all occurring with inside that gap period. And so they actually came and foreclosed on the property. And so the owner lost their property, and that's going to blow up to be a big giant problem. So title insurance does cover that gap period, which is good. Just need to make sure that everything was done correctly on the title side. And I'm looking at the question again. I know I was going to say there's always a bring to date that occurs. So you open a file on June 1, and then you're going to close July 15. There's a updating of that title search within 7 days before close. So that helps. It's not that first report and then now we're closing, and it doesn't matter how long it is. There's always a bring to date.
Scott, I know we lost you, and you may want to
Yeah.
follow back up with what you're saying.
Yeah,
Let me
I
just
went
bring you up
from-
to speed with the question we were dealing, or that we
Sure.
just that Alan answered, which is how do you handle liens filed in the gap between obtaining the abstract of title and closing?
Yeah. I'm going to go back a moment.
Sure.
And a lot of times people will get, and if you're putting up a lot of equity in a subject to transaction, you may want to get title insurance, because everybody's risk aversion is different. So it comes down to a personal preference. And is there a protection mechanism there? Sure, there is. However, a lot of people will buy a property and they will obtain title insurance, and they'll get an owner's policy. And, it's been problematic with FHA and VA. The good news is today we're able to issue title insurance today on FHA and VA underlying debt, but policy when they're buying the home subject to, with the intent to do a wraparound mortgage. And what they failed to understand is that the moment you do that wraparound mortgage, poof, your owner's policy is gone. And so you may not necessarily want to buy that if that's your back end intent, because it's going to go away very quickly. Now, to go answer your question, Andy, about the lien and the gap, and I heard part of Alan's answer, which is on point. You know, sometimes that happens. I've had that happen only once in 30 years of being a title attorney. But can it happen? The answer is yes. Just like what Alan said, one of the rules in my office in title insurance is that bring the date. And liens filed in the gap is my understanding, is the number one risk of loss that title insurers are out there, because that's the risk that they take on. And it can happen, but you hope that in that 2, 3, 4 days between the time you do your bring the date and your closing, that it doesn't.
All right. All right, well, guys. Well, that's all the questions we have today. Scott, I know you had wanted to mention something. I think you just mentioned it a little bit ago, but you had wanted to give an announcement last week, I think, and I cut us off short. And that was some of what you're able to close on, or what you're able to do now with your title company.
Well, I've got no pride in that stuff. I'll talk about things all the time, you know. I believe in shameless free advertising. No, but no, as we're out there, you know, we are able today in both Texas and Arizona, which is kind of nice, that if there is an FHA, VA underlying debt, we can issue title insurance on that, whether it's a wraparound or a subject to today. And because that's been an issue here for a while, it's nice to have that. And we hope to have that set up for us nationally under our OFN national escrow entity to do it in other states as well. So working on those things, trying to solve issues for our investor community along the way.
All right, good.
And thank you, Andy. I appreciate that.
Yeah, no, good information. Well, like I said, that is all the questions we have. I know you guys are busy and running around. Thanks for taking the time, and let's do it again next week.
Thanks, guys.
All right, we'll see you.
Thanks, guys.